is their stand in the in today's affidavit?
It appears that they are trying to defend the action that uh, candidates with open university degree 3 years course should not be allowed to participate.
Where is that?
My lord.
State of Bihar is taking a view different from the view taken by the UGC. Read paragraph 5.
That the UPSC therefore does not stop a candidate from filling up the application form of the commission's examination, including civil services.
Who is appearing for the UGC?
UGC. Yes.
You are appearing?
Yeah.
Yes, what is your submission?
We don't distinguish open distance learning from a regular one, Lord.
So there is no distinction.
No, Lord.
Then
That we have my paragraph 4 categorically I have stated, Lord, in my counter, Lord.
paragraph statement in paragraph 4 makes
4.
everything clear. Mr. Kaushik, is
My-
that the correct approach?
My lord.
It seems that
unless and until there is a requirement of
10 plus 2,
+2,
then otherwise
the
it
degree
has no
should be
distinction
treated to be
between.
valid. So what appears from the counter affidavit is that the 1985 regulations were amended in the year 2017. So therefore after 2017, the candidates who have been admitted to such degrees, their degrees may not be saved by the 1985 regulations. My lord, on the last occasion I had submitted that in 2014, under section 22 of the UGC Act, a regulation had come for specification of degree. That specification of degree also had an entry qualification of 10 plus 2 with BCom. But to that extent, I will add to my submissions that since 1985 regulations were a special law with respect to open education, and 2014 was a general specification of degree, the 14 would not impliedly repeal the 85 regulations. So therefore the degree would be valid until the regulation 85 was amended in the year 2017. Today a counter affidavit I have just seen has also been filed by the state of Bihar, relying upon certain decisions of the Honorable Madras High Court, also affirmed by the Honorable Apex Court in one case. But my lord, as I could see, the first
Today
decision,
something has been filed. Is there stand in the in today's affidavit?
it appears that they are trying to defend the action that candidates with open university degree 3 years course should not be allowed to participate.
Where is that?
My lord, no direct statement, but the orders which have been relied upon, there is a statement that in those cases the concerned candidates with the same degree were not allowed, and then it is stated that the writ petition is fit to be dismissed in paragraph number 21. Now, as I could see the 4 decisions which have been relied upon, in the first case, in paragraph number 15, issue has been framed by the Honorable High Court.
Annexure 1, Annexure A.
Annexure A, and relevant page is
Page?
page 28. In the instant case, para 15, page 28, in the instant case, the question is as to whether a candidate, after obtaining such a degree from an open university without completing 12 years schooling, can claim as a matter of right promotion to the higher post, ignoring the service conditions prescribed under the aforesaid service code. This judgment was also considered in the judgment of P. Raman, which I had cited in the compilation. This judgment has been considered, that is with respect to an examination for civil services conducted by Tamil Nadu Service Commission. This was distinguished in that judgment reported in 2014. Now next page is the dismissal of SLP. This, my lord, annexure C, as I could find, the paragraph 6 of this order at page 33, it says this court is of an opinion that the candidates appointed for teaching faculty must have undergone the regular pattern of education The persons who have studied through Open University system and correspondence courses are certainly not eligible to be appointed as assistant professors or teaching faculty in colleges and universities. The nature of job is imparting education to the students. The candidates who have undergone the master's degree courses through Open University system may not be proper persons for imparting education in colleges and universities. Thus, it is made clear that the competent authorities, while undertaking the process of selection, should ensure that the candidates who studied in the regular educational pattern as prescribed by the University Grant Commission alone are selected for appointment to the teaching faculty. The University Grants Commission also issued regulations to that effect. This would distinguish this case, because in that situation UGC itself has issued regulation that unless and until they have had regular pattern of education, they should not be appointed as assistant professor. This also may not be applicable to the present case. And in the last case, it appears that there was a guideline that admission to B.Ed cannot be given to candidates who have not undertaken regular schooling of +2. In the present case, my lord, the rules are that candidates who have acquired the bachelor's degree may be eligible to participate in the selection processes. There, these candidates cannot be denied the opportunity as their degree is valid, as the UGC has also filed counter affidavit. All the regulations which I had given in the compilation now stand admitted. I was of the opinion that there may have been some other amendment or regulations, but everything appears to be in line. So until the year 2017, when 1985 regulations were amended, the degree should be treated to be valid.
Yes, that's all. Yes, any submission? You are representing whom? Yes. You are also not taking a view different from the view taken by the UGC. State of Bihar is taking a view different from the view taken by the UGC.
My lords, just wanted to bring to my lord's notice. I am not having right now that order. My lords have passed one of the orders, one of the writ applications.
Please put on your mic.
My lords have passed in one of the order in another writ application touching the same issue, my lords. I am just bringing to the
Where
notice.
is that?
Because that I could not, today I could not, but that order has also gone into LPA, and my lord's view has been affirmed that there is a requirement for doing +2, and the BPED degree is not equivalent to that of the +2.
No, but there must be requirement in that case. Unless there is a requirement under the statutory rules
Because that is there,
relating
but,
to recruitment,
plus-
that one must have passed.
but lords, not representing the UPSC, but as the officer of the
Right,
court,
right.
lords,
We have
my duty to-
everyone has a duty to
Yes,
decide a list.
So losses want I can
proper.
show that on the next date, since today's list has collapsed. But that issue, Honorable Mr. Justice Gupta, sitting with Justice Mohit Shah, has taken up that matter. Party name I could remember is Rani Singh versus State of Bihar. The same issue had gone, but my lords had indicated, Mr. Jhat, my senior, that my lords have gone to a greater extent, greater issue is involved. The UPSC has taken this stand that there is no any
No distinction.
mandatory, lords, I can show it from the affidavit, lords. Affidavit, lords, the running page, lords, is at page 103. The aforesaid rule does not specify whether the degree is to be obtained after getting / passing the 10+2 or equivalent examination. The only requirement is that the degree should be issued by a university or an educational institution recognized under the relevant law of the center or state legislature, that as per the existing practice of UPSC, at the time of filling the detailed application form of the Central Services Examination, second stage, the candidate needs to fill the details of educational qualification, commencing with matriculation or equivalent till graduation, Along with this DAF, the candidate is also required to submit relevant documents. Such documents including 10th or equivalent and degree certificates are verified by the Commission in respect of claims made by the candidate. That it is emphasized that at the application stage.
So clear in paragraph 5.
Yes.
This is the only dispute.
One more thing, my lord.
Paragraph 5, please read paragraph 5.
That the UPSC therefore does not stop a candidate from filling up the application form of the Commission's examination, including civil services examination, on the ground of having passed 10+2 or not.
So, and the BPSC is stopping.
Is stopping, my lords, as I could gather from the writ application, the entire apprehension of the petitioner is that in the application format that is provided on the portal,
This is the stand of the BPSC also. This is clear stand of the BPSC that unless they fill up that part, their applications cannot be accepted.
yes,
That at the initial stage, UPSC doesn't stop the candidates. But at the time of filling up of the mains application form, one has to give the details, right?
Yes, he has to give the details of having passed 10th examination, 12th examination, but it does not stop. It does not. UPSC is not stopping from participation. You are stopping from participation.
Right?
Huh?
In the column of the 10+2, no.
He'll say no. But that will not amount to not accepting the application form itself.
What has not come forth in the affidavit is whether such candidates are finally selected or not.
No. Finally selected, they say that they are eligible. It is emphasized that at the application stage, only eligible educational qualification is required to be filled in the by the candidate before successfully submitting the application form for examination without submitting any document. Issue of obtaining degree without 10+2 may be looked into by authorities concerned of the government in order to decide validity or otherwise of such degree. So it will depend on, suppose there is an institution which grants degree without 10+2. That degree may be found to be invalid in accordance with the in terms of the rules. Then the UPSC may reject that. But it cannot decline, or it will depend. This is the view. No. You are generating litigation. You should have been clear. Or let me see. It will come after 4 weeks. In the meanwhile, if possible, I will write the judgment and.
can I give the copy of that order?
Please do that.
Prospectus of the IGNOU, it has been made very clear that it should not be treated as equivalent to 10+2. This BPP course, this bridge course
Yes.
should never be treated equivalent to 10+2.
No, 10+2.
It is only
When
the
there
higher
is-
degree which is
when
valid.
when there is requirement of passing of 10+2 examination,
Then they are not eligible.
a person who does not have the qualification cannot be held to be qualified unless, even if he has any higher qualification. The bridge course is probably only for the purpose of preparing a candidate to participate in the degree course.
Mile.
So that is the only purpose. That cannot be treated to be equivalent to 10+2.
The only purpose is that those who could not go to school
Right.
and could not be formally educated, they also
To bridge
can
the gap.
to bridge the
To
gap.
bridge the gap, some information, some training, some education, for that only. That is the purpose of the bridge course.